chapter. I'll just give you a moment to find that chapter in the section 32. Shall we press on? Thank you.
Good morning. I'm Debbie Hogan, Senior Policy Planner and Chapter Leader for the Rural Chapter. I'll just provide you with a brief introduction to the chapter. The Rural Chapter manages rural zoned land which covers a large part of the city. The overall outcome for rural land is to have a productive and diverse rural environment. So the chapter seeks to achieve this through maintaining a rural working environment and supporting the rural economy by ensuring rural activities have a direct relationship or dependency on the rural resource, natural feature or a rural activity. It's also going to be achieved mainly through managing rural dwellings and making sure that they're established at appropriate densities to maintain character and avoid rural residential development and ensure that that supports a consolidated urban form, in particular around the peri-urban fringe of the Christchurch main urban area. So it's proposed to have 6 rural zones. Each zone is distinguished by its geographic location and its main function. Within each zone, a range of rural activities are provided for, based around farming and plantation forestry, with a range of activities that support rural land use, including rural tourism, recreation, and the ability to sell and add value to products grown or produced on site. Development controls have been kept to a minimum to maintain rural character, or rather to focus on maintaining rural character and managing effects, including reverse sensitivity effects on rural activities. Most of these rules are similar to the operative plans, including minimum site size, and there are no significant changes proposed. A restrictive approach has been proposed in the rural urban fringe zone, and this is the area, the zone that directly adjoins the main urban area in Christchurch on the flatland. A restrictive approach is proposed due to existing intensive land use pattern and the number of pressures that are placed on this area from the urban environment. In particular, this includes limits on dwellings and subdivision on sites less than, or creating sites less than 4 hectares to avoid any further rural residential development. And this is in response to higher order policy directions contained in the regional policy statement and the land use recovery plan. A number of minor changes have been made to the chapter following the version discussed with councillors in January. This has been undertaken to take account of legal reviews, achieving the statement of expectations, and in particular integration with the Banks Peninsula landscape provisions of Chapter 9, which Caroline will outline shortly. And you will see that the rural chapter has expanded as a result of inclusion of these landscape provisions for Banks Peninsula. The key change since January is in response to discussions with councillors on quarrying activity related to the rural flatland. The provisions that you see before you now include notification clauses for quarrying activity within 500 metres of a residential zone. Since the chapter was printed earlier on in the week, an amendment has been proposed to address further concerns over quarrying and excavation within 1 metre of the seasonal high water table. The activity status is to be amended from discretionary to non-complying. This retains the status quo of the existing operative plan activity status, and the resolutions proposed before you reflect these changes that need to be made. That's it, that's my summary.
Do you want to go through the resolutions?
I can go through the resolutions for you.
Could I just ask a quick question through Chair? And Tim's the Deputy Chair. Just with consents, you're probably aware we've been having a conversation about the called aggregate, that's the combined group, aggregate quarrying and applying. You'll be aware of this, yes. So I guess it's just joining up those two.
Yes.
Stations applying for,
Yeah.
yeah.
Yeah,
What is it? Variations? Everyone's aware.
I would just take them through so that they understand the resolutions.
Okay. Yeah. So in response to those recent changes for the 1 metre seasonal high water table, the resolutions outline those changes. So in particular, for the rural quarry zone, currently we have it listed as a discretionary activity. It's proposed to delete that, replace that with a non-complying activity. So this is where you excavate within 1 metre of that water table. And there's been subsequent changes to delete references to matters of discretion. Actually, hold on. There needs to be a slight correction to point C. Apologies. Instead of the second column discretionary, it needs to be amended to non-complying. Yeah, just to, yeah. It was somehow escaped. Thank you. And then further down, just to also reflect where this quarrying activity will occur and where the groundwater resource exists, we also need to include the non-complying activity in the rural urban fringe, which is resolution 3, and in resolution 4 also include the same provision in the rural Waimakariri zone, which directly adjoins the Waimakariri River. And then as a result of those changes, the 5th resolution really is about addressing them, including that evaluation and any amendments within the section 32.
Just clarify the residential zone, the 500 metres is required to be notified from. Mm-hmm. Is that any residence or is that a residential zone? It's
worded as a residential zone boundary, so anywhere that there is a residential zone, it will be 500 metres from that boundary.
Where there are existing houses and uses, and the last one's gone within 88 metres of a house, how is that impacted? Is that the 250 metre zone?
No, it is written to have regard to that zone boundary regardless of whether there are dwellings there or not. So if it was, in particular, there's areas that have been rezoned residential new neighbourhood, and obviously they're yet to fully establish their development. So the way the rule is written, it will be directly from that residential zone boundary, even if there is no dwelling there.
Okay. So we currently are going out with 250 metres that you can't quarry within a residential zone.
Correct.
And then another 250 metres from that residential zone you must publicly notify.
Yes.
So 500 metres publicly notified.
Yes.
For those existing houses, and especially in the Yaldhurst Road area, that are established, I'm not sure what their zone is and how close a quarry may continue to encroach on those houses.
Yeah, so those existing houses in Yaldhurst Road are zoned rural. They're part of the rural urban fringe. So the way the rule has been written is that it only is from a residential zone boundary.
Right.
Any dwelling that has established in the rural environment, whether they've been there for a long time or are new, won't have the same limitation, the protection. They are required, though, if it's a new dwelling going into a rural environment, there is a separation distance that they are required to ensure that they... So the onus is on the new dwellings going in. It doesn't deal with existing dwellings.
So for those existing dwellings who have now got a quarry 88 metres from their door, what protection does this provide against quarrying, encroaching, basically? Wow, okay, none.
Well, this is the matter of reverse sensitivity. When people choose to live in a quarry zone, when they undertake the purchase of the property, it's on their onus to understand what can happen in that quarry zone. Mm. And as we know, these rules aren't retrospective. We can only write rules with respect to what Debbie was saying about a buffer zone for how to exclude them from a certain area from a quarry when it's a new house that's going in.
So for those existing houses, how do we actually protect them from a quarry on their back doorstep, actually? Like, because they are getting just resource consents to come closer and closer.
Well, if it's a, if it's within the rural quarry zone that the activity is being undertaken, then there are restrictions around that. If they are undertaking, if a new quarry or an expansion outside of the quarry zone, it will require a discretionary activity consent. So at that point, those existing dwellings will be taken into consideration. So they do have an opportunity to be considered, to be considered effective.
So is there a way then that we could do what Amy Adams was suggesting and actually make sure that those are all publicly notified by having that public notification hearing done by councillors or the local community board?
Any, as I understand it, under fairly recent changes to the Resource Management Act, an applicant can request to have an independent commissioner, and if that's the case, then that's what will happen. The applicant has that opportunity.
For the hearing or for the public notification?
For the hearing. Section 95? For the hearing.
Yeah, but for the Section 95, the council laws or the local community board could be the Section 95.
I would have to come back to you on that. I understood that that delegation is given to the resource consents manager, but I would have to come back to you on that.
Okay, but presumably it's a delegation given by council?
Yes.
Right, so we could alter that component.
I couldn't answer without having some legal advice.
Can I just ask a question around the wording of the seasonal high water there? It just seems to me that, can you? I'm not quite sure. Is that like a set table for right throughout the year, or does it vary?
I might have to defer to Adele to respond to that.
Where I'm coming from is that seasonal, especially with climate change, varies much more quickly, and that concerns me that we might be relying on a part of the year.
Well, my understanding is, well, we divert to Environment Canterbury for that information, and so they have their own monitoring, but the actual seasonal high water table, I can't recall the exact months, I think it's between September and April. Where is it the other way around? April and September, sorry, yeah. So that's when they determined that the highest water levels are, and then when we get an application, and we would liaise with Environment Canterbury for that data. And look,
thank you for that. And I guess like what happened last year in March is an example where we had flooding and the water table would have been much higher, and so it just concerns me that in other months, in fact, the aquifers may also be at risk.
I guess that would be a situation where you'd have I don't have the data.
No, I appreciate it's an ECAN matter that they monitor, but...
you'd assume in that scenario that you'd have you're indicating that you'd have a high water table outside of the typical high water months, which would be rather unusual, but... but whether or not that's actually higher than the highest season, I don't have that data.
Do we know why it has to be seasonal? Like, why can't we just have a fixed point?
We need to be consistent with Environment Canterbury, and they use that seasonal high water table, and because we're relying on their data and their monitoring, and that's what they're using, we don't have different data to look at a different level, if you like.
Okay, thank you. I appreciate your position. I guess just in terms of what ECAN might have, I can't be entirely comfortable with this still. But maybe it needs further discussion with ECAN, but I'm aware we have to sign this off today.
Just in relation to that, so ECAN have a role in their land and water plan where it's a restricted discretionary activity to do exactly the same thing for an excavation within 1 metre of the seasonal high water table. So if somebody is coming to us for a resource consent, they also need a consent from ECAN. So as part of any pre-application discussion, the applicant would go to ECAN in the first instance to determine what that seasonal high water table was, and then if they were coming within that 1 metre, and then they would submit essentially a joint application as per what is currently being submitted to both councils at the moment.
Thanks, Debbie.
Could I also just add, just for your information, I understand that the Mayor is wanting to write a letter to Dame Margaret Baisley in ECAN around these particular issues urgently, and to bring these issues to the Minister for the Environment, Nick Smith, for some potentially urgent action, definitely for further research on the accumulation of these types of consents coming through. So if that letter went out fairly quickly, then there will be at least a 6-month gap before this matter is heard by the hearing panel, in which potentially something could happen.
Okay.
I think that as a discussion, obviously we can make decisions today that perhaps your committee should discuss with ECAN with regards to there should actually just be one level rather than seasonal, because it does fluctuate, and therefore is it a possibility that some quarry could actually end up in the water table level?
That is a possibility, but what Debbie's saying is currently by law we have to be consistent with and give effect to regional plans and policy statements. So there's the RPS, but there are other regional plans too, such as the Airland Water Plan, which has rules in it relating to this. Absolutely. So what I've just said about the Mayor writing to MFE and to ECAN may potentially have an effect on changes to those regional plans. It depends what they decide.
But the possibility is that through the plans that we have now and that which we're signing off, there's actually, if you want, technically a fault, because there could actually be, as the water tables vary through the seasons, there could actually be inadvertently a quarry going into that. There could be,
but we don't have any research to justify what you're saying.
Yeah, I totally understand, but I'm just saying that for us as a council, it's certainly something we should be talking with ECAN about.
Yes, that's right, and that will be happening. I'm sorry, we can't hear you.
So is that wording that you've put in there about the seasonal high water, is that the actual ECAN wording in there?
Yes,
yes,
it is.
Land and water?
Yes.
Right. Okay. The issue of the existing houses, I appreciate they're in a different zone, but the quarries are going incredibly close and in some cases destroying existing businesses as well. Such that we look at the possibility, and it's outside of the district plan review, but just a note that we remember to do it, that we look at the possibility of the community board being the Section 95 hearing panel, the relevant community board, probably most of the
So what we'll need to get is some legal advice for you on that.
That's
what you're saying. Okay,
Thank you.
There's a note just to say request legal advice for opportunities for the community board to be a part of the notification decision framework.
And perhaps if Q or Chris might also note that the ECAN committee have discussions with ECAN around this issue. So we make sure we do have those. I'm sure we will. But.
Thanks.
Yeah, can I just check? My understanding is we can make this a publicly notified activity, so I'd rather just do that than leave it to the discretion of a hearings panel. I think there's certain activities in our city, like PD centres, like quarrying, that the community actually want to be notified on, and I have no qualms about actually just saying in our district plan that they will be a publicly notified activity. Right. So I'd prefer to take that approach if we can.
Can we? What exactly are you asking? What be a publicly notified activity? Quarries in rural zones where they're allowed to quarry?
Yep.
Within
all quarries?
Within certain distance of residential.
But we have got that. Debbie's already told you we've got that. Of residential zones, we have got that in here.
Is there a way that we can extend that to residences, as opposed to residential zones for the 250 metres?
Well, this is what I was talking to you about before. This is the reverse sensitivity of people choosing to reside in a rural area. You could do that for quarries, you could also do it for spray drift, you could do it for noise of cows or whatever. I mean, this is the problem with people who decide to live in certain areas. And of course, farmers will want to locate in the middle of their business, which is in a rural area. But these are the difficulties, the balance that needs to be done between understanding how to manage these zones.
But in the most recent case that we had in Roberts Road, the commissioners looked at a 250 metre buffer zone as being the minimum, as being appropriate for all sorts of noise, dust and all sorts of other things. But what we're doing is allowing quarries that are encroaching on existing residences, albeit in a rural area, to go much closer than 250 metres.
I think there's actually two different things. One is the existing rural quarry zones, which have existed for a length of time, and we are retaining those and the ability for quarries to continue in there. As over time, yes, there have been further intensification of dwellings within that vicinity. So the current plan actually already has a separation distance for any new dwelling moving into that area needs to be 250 metres from the boundary of a legally established quarry. So we have carried that across. So the onus is then on any new dwelling moving into that area to meet that separation distance. If they can't, they need a consent. And then for any quarrying activity outside of those quarry zones, it requires a discretionary activity consent. And then the range of assessment matters that need to be considered will include whether or not they meet industry standard separation distances, which is based around the 250 metre. So just in terms of that...
clearly not sticking to the 250 metre.
Well, those are previous consent applications that have occurred, and they will have reasons behind why they allowed a lesser distance. So we have reinforced the priorities for the rural environment and the complicated issues around quarrying within this revised policy framework in the district plan, and I believe it has been strengthened. Our assessment matters have been strengthened. I believe we're sending a clear message about quarrying, certainly within close proximity to residential zones.
Which is fantastic for the Gilberthorpe's area. Yeah.
And I think the flip side of that is recognising it's a rural environment. Quarrying is a legitimate rural activity and we need to provide for that. In providing for it, we've recognised it has adverse effects. We have taken account of those or required an appropriate activity status. So I believe that the framework that we have before us will be appropriate to manage those activities in future.
The concern I have is that we're actually, so to go into the seasonal high water table, it's publicly notified to go next to a residence. It's not. So I would have thought the resident should be able to, we're not saying stopping the activity, but we're enabling the resident to actually be involved in the decision making so that the adverse effects can be discussed, mitigated, etc. So if you look at page...
To be fair with this, Yanni, though, like you're asking the same question in a different way, though. I understand what you're saying. What you're saying is that you'd like a resident to be notified of that. However, if that resident has chosen to live inside a rural area, then quarrying is a legitimate activity, so they've effectively foregone that.
Within a certain distance. So if you take 3 and 4, all I'm saying is I can't understand why we can't put that last sentence into those other rules around quarrying relative to residential.
Quarry, yes. But then a quarry seeks to expand and it may go much closer than 250 metres to a residence.
It may, and that will be considered as part of that application, and it may be declined on that basis.
Or it may be approved as it just has been.
Well, it may be approved with conditions to mitigate those effects. So, and that's part of the consenting process that needs to be considered.
So what do you want to move, Yanni?
you read, we don't, so I don't quite know how to quickly reference the rules around the residential. Is there a page with a quarrying?
It depends on the zone.
How much more do you have of this? Because when we get to the resolutions, we know there's going to be a resolution at the end, and maybe if you've got an amendment, you can think about the wording for that and bring that to the end. How much longer do you have on the rural chapter?
Well, that's it. I mean, we're here to answer
I've
your
finished,
questions.
I've got the
Oh,
update.
and
Yeah.
Caroline's just going to give you an update on the
That's
landscape.
in relation to
Yes,
this.
Nash Quarrying.
Sorry, can I just ask one question in relation to the overall objective of the rural environment, where you talk about it being, and sorry, I can't.
Move. Can you move back up, please?
Productive and diverse.
Oh, that was not included in the resolution.
No,
it was
it
in my.
was-
It's yep,
Is it part of the objective that it be productive and diverse?
correct. It is.
And
Yes.
is there any environmental objective in the rural zone, such as where, I don't know, protection of water or anything?
No, not in the rural zone. You might
There's
recall
one in
that we made that agreement that it go in the Natural and Cultural Heritage chapter, but I also understand there is an objective, a high-level objective in the Strategic Directions chapter, which we won't know whether that's succeeded or not until we get the first lot of decisions.
So in the Strategic Directions chapter, we have a high-level objective that is about protection of the groundwater aquifer.
We had, yes.
had?
We need to, well, I don't
We
know
have,
what is
but
in
we
there
don't know the outcome.
until the decision is released, which I believe is next week.
So we have put it in, but we don't know the decision.
And it's also in the Natural and Cultural Heritage chapter, which is yet to come to you.
Right.
And the rural chapter does include references to it throughout the chapter. There is one reference to groundwater in relation to policy 17.1.1.10, which relates to the location and management of quarrying activities. And in particular, it's one of the criteria in terms of avoiding particular locations for quarrying. So as I said previously, I believe that we have quite a strong policy framework and we're sending a clear message, and that combined with the policy in Chapter 9 and strategic directions.
Can you show us the areas where we are avoiding quarrying, and just in relation to what you've said? Is that possible to show us? Refer us to that?
You will have been, well, it's not so much avoiding, it's a consideration that we need to take into account.
When a consent comes in.
When a consent comes in. So
yeah. So there aren't actually areas on the maps that says this is where we're avoiding it.
So it's a policy framework that says if somebody's looking for a new quarry site, they will look to the rural chapter and look through the policies and see what that is telling them, and then what activity status they need to jump through. And then we will use these policies in assessing any application. So there could be a reason to actually decline, and that the activity is not protecting groundwater from the effects of filling and use and storage of hazardous substances. So unless they can prove otherwise, there could be a reason to.
So Debbie, are those, like, when it comes out, are those cross-referenced, those links, so people can find their way from, for example, major objectives to the rural chapter? Is there a cross-referencing?
In the E-plan, you're meant to read them together as a package anyway.
We can make sure that there is
link it.
cross-referencing put in there
Thank you.
once these chapters go into E-plan.
Yes.
Right, thank you. That will really help everybody.
Okay. Yep.
On quarrying, just in relation to the community board submissions, so we've stayed at non-complying because we can't go stronger than the regional plan.
Which is already different to the regional plan where it says restricted discretionary for this type of activity.
So we think that's as strong as we can go. Is there capacity for the community boards to put in submissions suggesting stronger rules?
I believe stage 1 you allowed the community boards to put in their own submissions, so I would have thought that you would continue with that approach. Yes. And this is why the Mayor has suggested that she will bring this to the attention of Ministry for the Environment and ECAN.
Right. Do we have a set of recommendations that you would need us to make a decision on now? Oh, yeah, go for it, Yanni.
So on page 20, you do have the quarrying within 250, is 250 or more from a residential boundary, zone boundary. So really the only difference we were talking about previously was that if it's next to a residential dwelling, then you're saying that we can't do that because those dwellings are in quarry zones, and it wouldn't be fair.
Those dwellings would be in the rural environment.
So
in other words,
dwelling.
any quarrying activity would need to be notified because of the way that dwellings are scattered throughout the rural environment. And I think, personally, I would find it difficult to support something like that, just purely on the basis of how this chapter has been developed, which is, like I say, the premise is there's a resource out there, it's a legitimate rural activity, we're managing dwellings that locate within that area, and yes, we are dealing with a very complicated existing situation out there, but the onus is really on any new dwelling coming into that area takes that responsibility to locate.
What about an existing dwelling?
Those existing dwellings, yes, I admit that they are difficult to deal with, but once again, it's then the responsibility is on the quarrying activity, and we would assess the appropriate distance, which they may or may not be able to achieve.
I think that's the thing for me, is that if you think about the RMA, its purpose is to mitigate adverse effects on the environment and allow for sustainable development. And it seems to me that the people that are adversely affected by the activity, regardless of which zone it's in, should have a fundamental right, particularly I would have thought with the activities like quarrying, with the adverse effects that it will generate, to actually be notified if it was happening next to them. That to me just seems like a really fair thing to expect. It's not to say that quarrying is banned or prohibited in those areas. I understand there's a need for it, but what I can't understand is why we would remove the right for the person, or not make it explicit that the right of those people that are adversely affected to be involved in that discussion when the consent is approved, particularly if it was even closer than 250, which it seems like it could be, and it still wouldn't necessarily be publicly notified.
Well, that's a decision that would be made as part of any consent application received. Firstly, you have to identify affected parties. If you can't get their consent, then that's a reason to notify. Or that operator might just choose to notify the application, or as a result of assessment of Section 94 that the consents team decide that it needs to be notified.
Or we could just decide now and put it in the plan.
I would have problems with putting it in now because, as you rightfully said, it's to also allow for the sustainable use of natural resources. Now, these zones are in those places where these natural resources are located. And for residential activities, the primary use of those zones is for residential activities. So to put every single consent out for notification when that can be judged at the time of the consent potentially is a misuse of that notification clause. It can be decided at the time of the application.
And this needs to be defended or defendable by our officers and their professional opinion there. And we've heard the answer that that's not the case. I can understand what you're saying around it. I understand, I understand the pressure points at both sides of the spectrum, but in all honesty, this is a rural zone. And I understand what you said. I appreciate that. Is there anything more?
And also we are getting the legal advice that you have asked for as to whether community boards and or councillors can be a part of that decision making regarding notification.
Yep.
So can I just be clear though? 250 metres of someone's house, if they're zoned in a residential, a rural area, there's no guarantee that will be publicly notified, that activity.
There's no absolute guarantee,
I could be 10 metres from the house and I could basically say that I've got everyone to sign it, and I could say that there's going to be no adverse effects.
That's correct, but it is a full discretionary consent.
But it's not. But no, it's a misrepresentation. You can't just say that you've got everyone to sign it. You know, like.
Well, actually, this is what happens.
Yep. So if
Remember-
they've actually
remember the
physically
Roberts
signed
Road
it, signing it means that they've given their consent and wavered
Yes, but
their
people
objection
often
to
don't
any of the
understand
mitigating
what they're being asked
factors.
to sign.
No, but they're
I
not
don't
even
care
asked,
if they don't-
Johnny.
And
They're not
sometimes
even
they're not
asked.
even
So
asked,
Roberts Road, for example, right next to a major residential community before this part of our district plan was altered. Not one of those residents was notified, despite the request from the council to the commissioners that the request would be publicly notified.
So how many metres was that from the
So
residents?
the commissioners established at 250 metres. The risk is that it will actually go closer, and that hence the very grateful for this going in the district plan, and I hope it gets there very quickly, because the risk is that they want to go even closer.
So what's your suggestion? What's defendable, I guess, from your perspective, and the pragmatic way forward?
Well, there are two issues here. It's what Debbie feels as a professional planner that she can support, but then there is also the issue of what will get past the Minister's comments. Given that we're currently in recovery mode, and then there's a certain amount of aggregate that's required for that, I don't know how the government might see this kind of a clause.
I could guess, but anyway, look, have you got something that you would like to? Oh, let's get this moved and seconded. I guess the staff recommendation.
We've gone back to non-complying. I mean, the danger was that we actually moved up the scale of liberality. We've gone back to non-complying, and that's as far as we can go. Can I just be clear? What is the penalty in any law for anyone creating damage in our aquifer that causes major remedies to be needed? I would need to get you some legal advice on that too. Thanks.
Right. Okay, move, Paul. Is there a seconder for what we have there? Ali? Let's test it. All those in favour, say aye. Aye. Opposed? Yanni, do you want that recorded? Okay, so that's carried.
Now, there is a second lot of resolutions relating indirectly to rural that I'll ask Caroline to go through now. Of a residential.
Oh, good morning, everyone. So these are updates